pleasant day, everyone. I am John Marco Malubay, together with Sophia Manalaysay, Jerome Ignacio, Kyla Malang, and Marian Jacob, to discuss the topic number 5, characteristics of criminal laws, duration, and effects of penalties. Before that, let's have our topic outline. For today's discussion, first in line is the principal parts of revised penal codes. The next one is two essential theories in criminal law, and the last one is duration and effects and penalties. Without further ado, let's have Ms. Manalaysay to discuss the principal parts of revised penal codes.
Principal parts of revised penal code. Articles 1 to 20. Principles affecting criminal liability. Example of principles affecting criminal liability. Actus non facet reum, nisi mensi tri. Actus non facet reum, nisi mensi tri. It is the famous English maxim of criminal law. This maxim means the act itself does not constitute guilt unless done with a guilty intent. It is a principle of natural justice. The maxim is sometimes said to be a fundamental principle of the whole criminal law. Articles 21 to 113. Provisions on penalties including criminal and civil liability. Criminal law addresses behaviors that are offenses against the public, society, or state. Examples of criminal law offenses include assault, drunk driving, and theft. In contrast, civil laws addresses behavior that causes an injury to the private rights of individuals in areas such as child support, divorce, contracts, property, and the person. Example of civil law offenses include libel, slander, or contract breaches. Criminal and civil cases differ in who initiates the case, how the case is decided, what punishments or penalties are issued, requirements of proof, and legal protections provided. Articles 114 to 367. Felonies defined under different titles. Title 1. Felonies and Criminal Liability. Chapter 1 defines what a felony is, which are acts and omissions punishable by law, either by means of deceit or by fault. It defines who is criminally liable, whether a felony is consummated, frustrated, or attempted, when conspiracy and proposal to commit felonies are punishable, which felonies are light, less grave, and grave. The succeeding chapters list which circumstances justify, exempt, mitigate, and aggravate criminal liability. Title 2. Persons criminally liable. This title discusses who are the persons liable. This includes the principals, accomplices, and accessories, with the latter classification not used for light felonies. Title 3. Penalties. All penalties relating to death are commuted to reclusion perpetua.
Thank you so much, Ms. Manalaysay, for that wonderful discussion. We're now moving on to such legal terms. The first one is acts. 4,275 public laws enacted by the Philippine Assembly from 1901 to 1935. They stated as Act Number. In a general legal context, an act refers to a formal written document of legislation that has been passed by a legislative body. It is commonly associated with laws enacted by the Philippine Congress. Second in line is Commonwealth Act. 733 laws passed from 1935 to 1956, cited as Commonwealth Act Number blank. Commonwealth Act are laws enacted during the period when the Philippines was a commonwealth under the United States. They were legislative acts passed by the National Assembly during this time. The next one is Batas Pambansa. 844 laws passed by the Batasang Pambansa or the Philippine Parliament from 1979 to 1985 and cited as Batas Bilang Blank. Batas Pambansa translates to national law in English. These are laws enacted by the Batasang Pambansa, which was the national legislature of the Philippines under the Marcos regime. These laws were enacted from 1978 to 1986. Moving on, fourth in line is Presidential Decrees, 2034 enactments of President from 1972 to 1986 when the Philippines was under martial law. This is the Presidential Decree number blank. Presidential decree are laws issued by the President of the Philippines that have the force of law. During martial law 1972 to 1981, President Ferdinand Marcos extensively used PDs to enact laws without need of legislative approval. The last and definitely not the least are Republic Acts. Congressional enactments from the Philippine Independence Declaration in 1946 until Declaration of Martial Law in 1972. These congressional enactments were resumed in 1987 when the present Congress organized under the 1987 Constitution. There are now 9,000 Republic Acts that is known to be as the Republic Act number blank. Republic Acts are laws passed by the Congress of the Philippines and signed by the President. They cover a wide range of legislative topics and are primary legal instruments in the country. These legal terms represent different forms and periods of legislation in the Philippines, each with its historical and legal significance. With that, thank you for listening. Now, on to Mr. Ignacio to discuss the two essential theories in criminal law.
Two essential theories in criminal law. The first theory, classical theory. Classical theory characteristics. Letter A. The basis of criminal liability is human free will, and rationale of the penalty is retribution. So what does it mean? It means individuals have the ability to choose whether to engage in criminal acts or not. Rationale of the penalty is retribution. What comes to our mind when we say retribution? It refers to the idea that individuals who commit crimes should be punished in manner that is proportionate to that harm they have caused. Next, letter B. There is negligible or a little regard to the human element. It means that the statement is not accurate regarding in classical theory. In fact, classical theory places significant importance on the human element. Another theory is the positive theory. Positive theory characteristics. That man is occasionally obedient to a strange and dark phenomenon which constrains him to do wrong, even though contrary to his violation. The theory recognizes that there are complex factors that can push individuals towards committing crimes even if they may not want to do so. This means individuals may feel compelled or influence external factors to engage in criminal behavior. Next, that crime is a social and natural phenomenon and such it cannot prevent and treated by application of abstract principles of law jurisprudence nor by the imposition of a punishment. This means that simply relying on legal principles and punishment alone is not sufficient to effectively address and reduce crime. The theory argues that crime is deeply rooted in societal factors such as poverty, inequality, and lack of education, and the last is the social disorganizations. That are the two essential theories about in criminal law.
Thank you so much, Mr. Ignacio, for discussing the two essential theories in criminal law. Let's move on to Ms. Malang to discuss the duration and effects of penalties.
Duration and effects of penalties. Section 1. Duration of penalties. Reclusion perpetua. Any person sentenced to any of the perpetual penalties and after undergoing the punishment for 30 years, unless the chief executive shall consider such person of his conduct or some severe other cause as unworthy of pardon. Reclusion perpetua is a sentence commonly used in some legal system as an alternative to life imprisonment. An example might involve a serious crime like murder, where an individual is sentenced to spend the rest of their life in prison without the possibility of parole. Reclusion temporal. The penalty of reclusion secular shall be from 12 years and 1 day to 20 years. Reclusion temporal is a legal term of imprisonment that ranges from 12 years and 1 day to 20 years. An example of a crime that might lead to a sentence of reclusion temporal could be a severe case of physical assault resulting in grave injuries but not leading to death, depending on the laws and circumstances in a particular jurisdiction. Probation mayor and temporary disqualification refer to the duration of mayor's penalties. And temporary exclusion shall be from 6 years and 1 day to 12 years, except when the case duration shall be that of maximum sentence. Probation mayor and temporary disqualification could occur if an elected official is found guilty of a specific offense but is temporarily prohibited from holding public office for a set duration. For example, a council member convicted of certain legal violations might face a temporary disqualification from holding any public office for a specified period, usually ranging from 6 years and 1 day to 12 years, depending on the severity of the offense and legal regulations. Prison correctional, suspension, and desterro. The duration of the penalties of prison correctional, suspension, and desterro shall be from 6 months and 1 day to 6 years, except when the suspension as an accessory penalty, in which case its duration shall be that of the maximum sentence. Example of prison correctional, suspension, and desterro are a person convicted, a government official, and a case involving a land dispute. Arresto mayor. The duration of arresto mayor shall be from 1 month and 1 day to 6 months. Arresto mayor is a term used in the Philippine legal system to indicate a specific level of imprisonment for an offense. For example, if someone is found guilty of a crime that warrants arresto mayor as a penalty, they might be sentenced to imprisonment for a duration of 1 month and 1 day to 6 months, depending on the severity of the offense. An examples could be someone convicted of theft or physical assault resulting in injuries that fall under the arresto mayor classification. Arresto menor. The duration of arresto menor shall be from 1 day to 30 days. Arresto menor is a term used in Philippine law to refer for a penalty involving imprisonment for a maximum of 30 days as a form of punishment for committing minor offenses. For example, a person found guilty of simple trespass or slight physical injuries might receive a sentence of arresto menor, where they serve their time in jail for a short period, not exceeding 30 days as stipulated by law.
And to discuss the kinds of deterrence, let's have Ms. Jacob.
Kinds of deterrence. Specific deterrence. Individual deterrence often takes the form of an older principle called incapacitation. The idea is to make it impossible for individuals to commit another crime, at least while they're in prison. In this kind of deterrence is that if an offender receives a severe punishment for violating the law, Their ensuring punishment will discourage people for doing their crimes from committing in the future. For example, a specific deterrence dictates that if an armed robber receives a hard sentence of 8 years in prison, then he will be less likely to commit armed robbery again when he eventually gets out. Another example is you're driving drunk and you're just straighting down the road and you notice that a traffic enforcer is chasing you because you didn't stop when the traffic light turned red. You stop and the traffic enforcer tickets you, and because you don't want to be ticketed, you will not repeat it again. General deterrence, societal deterrence, is what most people mean when they speak of deterrence. The principle here is that others, potential criminals, will not to avoid criminal behavior because of the example provided by punishment. General deterrence focuses more on teaching the general public a lesson rather than just the individual being charged with the crime. The idea is that if the individual is punished harshly, the public will see that harsh punishment and be dissuaded from engaging in the same or similar activity. For example, this is the death penalty. When a criminal is sentenced, in dissuade the general public from committing the same or similar crime. Another example of general deterrence is the perp walk. Perp short for perpetrator. The perp walk is the act of walking an offender into or out of a police station, courthouse, or police car solely for the media's benefit and to humiliate the offender.
And that brings you to the end of our discussion. Time for questions. If you do have some questions, just kindly comment down below. Thank you for listening.